Thank you guys for tuning in again. This is the second week. We were in court for 3 weeks in a row, but this is the second week that we're out of court. So during this time, what we generally do is get ready for the next 2 weeks, and that trial roster will come out 3-4 months in advance. So we know what's up, and generally it starts off with murders, and that'll start next week. But since we don't have court this week, I wanted to talk with you about another topic that we get a lot of comments on, and it's always, well, this guy got this much time for a drug deal and you could get less time for murder. And there's some truth to that. I want to use this time to sort of explain what's going on and what's happening with all of that. So with drug offenses, those are what's known as enhanced offenses. And if you sell cocaine or crack cocaine or heroin the first time, that is a limit of 0 to 15 years, which means the judge could give you probation, the judge could give you 90 days, the judge could give you 15 years on a first offense. Generally, you won't get 15 years on a first offense. But in addition to the penalty, whatever you do get, you've got a strike on your record for drugs. So generally, when you see a person getting 25 or 30 years for drugs, it's not a first offense. You can't even give that much time for a first offense. It's a second or a third offense. Even when a person has a third offense, we will usually move it out of the mandatory range of 25 to 30 years back down to a number of about 10 or 12 or 13. That's where those sentences come from. So we go to them and say, if you want a trial, that's fine. If you are found guilty, the judge has got to give you this amount of time. That's the bottom line on an enhanced sentence. If you plea, you can plead to 10, 12 years. That's why you see a lot of people pleading to that amount of time. One other thing about drug sentences, we have numerous occasions where a person is charged with crimes against people, like domestic violence or some sort of attempted murder or shooting into a dwelling, and drugs. Obviously, and more especially with gang type cases, once we know that this is a really bad player, we very seldom can get witnesses to come in to those attempted murder cases. They have to live in the community, they don't want to deal with it, and they chalk it up to the street or whatever the phraseology is at that term. But you can't get them to come in without locking them up. And we have done that before. We've locked up victims and made them come to court. They don't make good victims. They don't make good witnesses. They don't want to be there. So what we've done a bunch of times is, if I've got you on a third offense for drugs and I've got you on a crime against a person and we believe you to be a danger, we will hold the line and give you a lot of time on drug offenses and not even worry about the other offenses. This idea is not novel. It's not new. I tell people all the time, you've all heard of Al Capone. Al Capone went away for tax evasion. You know, it doesn't matter how many people he killed. It doesn't matter how many lives he destroyed. Ultimately, you couldn't get anybody to come forward on any of those cases. So way back in the 40s and 50s, they got Al Capone on tax evasion. We sometimes do the same thing. We know it's a bad person, but we know that this is the easier case to try. So we go forward on the drugs and we get that person removed from the street. You know, it happens. But generally speaking, we recognize who people are mules that are just pinching off a little bit for themselves and working for somebody higher up. We get them all the time where we've got them on a third offense, and what we try to do is get that person to testify against people that are much higher instead of getting people further down the line. So that's the drugs, and they're enhanced, and it goes up tremendously um, in sentence structure. Also, you always get this about the understanding of what is murder. In other states, you hear all the time murder 1, murder 2, murder 3. We don't have that in South Carolina. We've got murder, then we've got manslaughter, and then we've got involuntary manslaughter. If you lived in another state, that would be murder 1, 2, and 3. Murder is the killing of another with malice aforethought. That means that you sought to do what you did. You used instrument of death most of the time, a gun or a knife or a dagger, and you thought it out and you killed somebody. That is murder. For that, that is one of the sentences where it's day for day. So murder carries from 30 years as a minimum. If the judge is your uncle, you got to get 30 years on a murder. The maximum is the death penalty. So anywhere between 30 years and the death penalty is the appropriate sentence for murder. If you were to get 30 years on that, you could add 30 years to the day that you're sentenced, and that is the day you get out. You could get 40 years, you could get 50 years, you could get life. And in South Carolina, life means that you die in prison. They leave you there for a minute to make sure you're dead, then they take you out in a box. We call it pine box life. That's the sentences for murder. What other states would call murder 2, we call manslaughter, which is the same as murder except that you didn't have the malice intent. Either you were seeing red, you were angry to such an extent that you couldn't conform your actions. We may let people plea that were originally charged with murder to manslaughter. Manslaughter carries from 1 year to 30 years. And that is what we call a non-parolable offense. You actually have to serve 85% of that before you would become eligible for parole. So that's language that the statute uses that's really inconsistent with what happens. But you do have to serve 85%. If you were to get 30 years on a manslaughter plea, you would have to serve 26 years before you came up for parole. Involuntary manslaughter is an accident. That is where you are playing with a gun or something like that. The gun goes off. You had no intent on hurting the victim. And that's a much lesser sentence. That's what other states would call murder 3. But it's just an accidental. The classic case is a person that's carrying a deer on their back through the woods, and a hunter, believing it to be a deer, shoots at the deer and kills the person toting the deer. That's involuntary manslaughter, and that's 0 to 10. So those are the sentences there. Domestic violence is another crime against people that gets a lot of traction, along with criminal sexual conduct, rape, what we call CSC. There are a lot of sentencing ranges there. CSC is broken into 2 parts. It's what we call statutory rape and non-statutory rape. Statutory rape just means that the person is too young, and that sentence structure is set up on how young the person was. So it's certainly a worse crime for a CSC when the victim is 9 than it is when the victim is 15. And the sentence structures reflect that on statutory rape or CSC. CSC that's non-statutory in nature is the most classic case. Is somebody uses a knife. That could get you up to life in prison for a rape with the use of a weapon. And then second and third on that is a person that's not a minor, but third is basically a person that's too drunk to consent or too doped up to consent as a victim. Alright, so the CSCs, when it's non-statutory in nature, the worst, of course, could get you life imprisonment, and that is a rape with a knife or a weapon. CSC second is, of coercion without a knife. CSC third is usually used for a person that's just too drunk to consent. Those are really, really, really hard cases because when you look back, most of the time there's no intent one way or the other. So we get it and understand that there's going to be a lot of questions about who gets what in court. But every case is different, whether it's a CSC, whether it's a murder. It's the state's job to tell exactly what went on. Then it's the defense's job to talk for the defendant personally, and that they will put up mitigating circumstances. The guy never graduated high school, the person's never been in trouble before, da-da-da-da-da. Those sort of things is what will be presented to the judge. So when you see sentencing ranges and you're like, well, why did this one get that? Without having the whole story, it's very hard to piece those things together. It depends on the judge. Some judges are harder sentencers than other judges. It depends on the defense attorney. Some are better advocates than others. It's really, the judge would make more of a difference than the defense attorney. The prosecutor, it really doesn't matter as much on a plea, because it's very common for us to, if one prosecutor is out, to hand the file to somebody else and that person go in and recite the facts and have the victim tell exactly what went on. But the defendant's prior record makes a big difference, especially in enhancement cases. The judge makes a difference, the defense attorney makes a difference, and to some extent the prosecutor makes a difference, and the victim makes a big difference. Sometimes you just can't get the victim to show up. That's one of the things that we struggle most with domestic violence cases, and that is why I have always said that the biggest advantage for us is when we have a place like the Family Justice Center, which provides suitable living conditions for a person that just become the victim of domestic violence. They also provide schools for the children, and they provide that much needed counseling that really pieces back the victim's life. That makes all the difference in the world, and one of the things that we have continued to struggle with, but we're almost through with, is Horry County doesn't have a domestic violence center. Anytime that we do get somebody in that need, we have to send them to Georgetown. In Georgetown, over 60% of their cases at the Family Justice Center is domestic violence victims from Horry County. So they've been an extremely good neighbor in Georgetown to Horry County. But those are some of the crimes, some of the things, again, you're very justified if you look at it and say, you know, there's confusion going on why does this guy get this sort of sentence and this guy get something different. And there's a lot to be said for that. But every case is different. Every plan is different. A lot of the times you see people get huge sentences on drugs. It's simply because we know that we've got them on something else where the victim won't come in. And it's just easier to prosecute them with a police officer finding a ton of drugs in a car stop. And that is easier for a jury to pick up, and it's tried in 2 days, and then almost like I mentioned with Al Capone, it doesn't matter so much what they're sitting in there for as long as they're not creating turmoil and strife on the street. That's the plan. There's no perfect system. Obviously, we don't do a perfect job. We do as good as we can, but those are some of the thoughts that go along with the sentencing structure. Think of it as a toolbox. We take the assets that we can and use them to the best of our ability to keep the community safe. That's sort of why we do what we do and why sentences come out the way they do.